start once again. Thank you all for joining us. This is, as our emails and our Facebook posts have talked about, this is one of our monthly webinars that we're doing, and it's going to be on estate planning with attorney David Guarino. We're going to be doing some other webinars throughout the coming months on things like year-end tax strategies and budgeting, divorce planning, which is going to be what we're doing next month in October, health insurance, Medicare, improving your medical score, or your credit score, and so on and so forth. Today's webinar will feature Dave Guarino, as I had mentioned. Dave and I have been working together for about 8 years now, and he's been practicing law for about 24 years and has both a JD and an LLM designation, which is pretty much a Master's of Law in Taxation. David concentrates his practice on estate planning, but also builds in special needs planning, and Dave and I have done some workshops on special needs planning in the past, around things like special needs, trusts, guardianships, etc. During the webinar, Dave's going to talk about different types of estate plans, your basic estate plan, which is kind of your will, power of attorney, healthcare proxy, etc. And then the more complex stuff like trusts, when they should be used, when they shouldn't be used. Also talk a little bit about estate tax planning. State tax planning doesn't really influence everyone because federally it doesn't impact anyone but the very wealthy people. But specifically in Massachusetts, Massachusetts actually does have an estate tax. It does hit people when they have over, usually about $2 million is when we start, well, $1 million to $2 million is when you have to start thinking about it. So we'll try to keep the presentation to about 30 to 45 minutes. We do have an ability for you to ask questions. So at the bottom of the screen, there is a Q&A button that you can click on. Feel free to ask questions during the workshop. I'll compile the questions, and Dave will, and then I'll ask them to Dave, and he'll take care of that. So with that said, here's Dave. Actually, before I do that, I do have to talk about the disclosures, which I just talked about a moment ago, but you couldn't hear me because I had the mute button on. So bottom line is just know that all this information is general in nature. Please don't act on it until you actually speak with someone like myself or David so that we can talk to you about your individual situation. So with that said, great. I'll turn it over to David.
Thanks, Brendan. We want to talk in two different concentrations today. One, we'll talk about what standard documents are for adults in Massachusetts, and then optional documents, and that's really where the trust discussion will be. So starting with standard documents, in Massachusetts, we would create, for the typical adult male or adult female, a last will and testament, a Massachusetts healthcare proxy, and a durable power of attorney. And let's run through how those work.
You want me to take it?
Just show me how.
That's all right. I'll take it.
Okay.
Just so, next slide.
Next slide, please. So starting with the last will and testament. To use a little bit of the jargon that Brendan doesn't like, the person that creates the will is called a testator. And so we'll just use that repeatedly as we talk about, rather than saying the person who creates the will is called testator for this discussion. The will is probably the simplest method to leave assets to your chosen beneficiary. And often what you'll see in a simple will be something that says, as an example, I leave the house to my brother, and I leave my bank account to my sister, and I leave the rest to my nephew. And the will, that will be delineated in the will about a disposition of property, and that's perfectly fine for what the will is for. The things to keep in mind with that will is that this isn't a document that's effective at the testator's death. So in my example that I just gave, where my will says I leave my house to my brother, and I'm still alive, my brother has no rights to the house. He has no ability to tell me that I need to fix the roof, or I need to pay down the mortgage, or he has any sort of protected interest in this. This is only effective upon my death. The will is something that I can change for the rest of my lifetime, and it's not valid, or it's not useful for disposing of property until I'm gone. And we'll contrast that with power of attorney and healthcare proxy in a few moments. But the general concept is that the will is, this is what I want, this is where I want it to go, and I have the ability to change those decisions, or the testator has the ability to change those decisions, as long as they're competent for the rest of their lifetime. At death, a will has to go through the probate process, and we'll talk about probate a couple of times as we're talking about trust and the rest of the other planning options. But probate in Massachusetts is essentially a process where after the testator dies, somebody has to go take his will to the probate court to get that will allowed by the probate court. And typically what the probate court is looking for is that the testator was competent when he signed and usually has followed the Massachusetts formalities for signing the will, which would be you have a notary and you have two witnesses. And until the probate court looks at the will and says, we allow this will, the brother in my example still has no right to say, I want my house, or I have an interest in the house, or the sister can't say, I can't go to the bank and say, my brother left me this bank account, I want it. Without the probate court approval, the probate process, then the will is not effective until the probate court has signed off on it. Typically, that's not a huge hurdle in Massachusetts, especially if you have two witnesses and a notary. There are sometimes when the will has flaws in it, or there's some questions about the capacity of the testator, but in general, the will is allowed, and it's allowed fairly quickly by the probate court, and at that point, the will is effective, and the sister gets her cash, and the brother gets his house, and the nephew gets everything else.
So just to be clear on that, Dave,
Sure.
one of the things that I hear a lot from clients is, well, I have a will, I'm all set, right? And I know we're going to get into that, and you know, some people, a will is really all they need, but for most people, they need other documents than just that. As it pertains to a will, how long does, so person passes away, they have their will, and there are things that are going to be given over. Let's say it's the house.
Mm-hmm.
The house is given to someone else because the will says the house is going to this person. How long would it actually take for that person to actually get the house? If you went through all the steps of the process.
Going through the probate process in Massachusetts isn't nearly as onerous as it is in other states.
Okay.
And so that would be done in pretty short order if there aren't creditors and making claims and there aren't issues with the will, or the brother isn't coming back and saying, I should get the house and the cash, or something like that would delay the process. But in Massachusetts, the probate process is quick, and it's even quicker now than it was, say, 10 years ago, or 6 or 8 years ago, before they changed the probate rules in Massachusetts. When you hear, though, the discussions about we need to avoid probate, I think that those generally flow from other states where probate process is significantly more burdensome than it is in Massachusetts, and significantly more expensive than it is in Massachusetts.
So I think in this workshop, we probably have folks from Massachusetts, New York, Florida, Texas, California.
Okay.
Any of those that
So I started practice in California,
okay.
and it was very much standard practice to make sure that you had your property in a trust,
mm-hmm.
because the probate process, at least when I was practicing out there, essentially said that even if all you have is one bank account, the lawyer gets a statutory fee based on the value of what's in the probate estate. So if that bank account held $10,000 or $2 million, the work to get that account to the beneficiary, in my example, my sister, is the same, but the fee that I get paid as the lawyer is dependent upon how big is the bank account. And a client who had a $2 million account in their own name, it's a windfall for the lawyer.
Okay. So person passes away January 1st. When do you think that house would be?
Let's not use the house as a bad example, because there are other parts, but the bank account, that you could expect that to be done in months at the worst, and maybe even less if you really expedite the process. So it's much quicker again in Massachusetts after the streamlined rules. The reason I'm hesitating on that is because you can technically get the asset to the beneficiary, including the bank account, pretty quickly. But what you're worried about is you gave the sister the bank account, then 3 months later, the creditors come and say, he owed us a bill. You have to get the money back from the sister.
Mm-hmm.
So that's where the delay in getting her the asset is. It's not the probate process itself. It's the concern for creditors who have an extended time to file a claim against the state.
Okay.
So to go to the typical structure of the will, I think that's what we have on the slide here. There are 4 points I think we should talk about in what you would expect to see in a will. For anyone that has children that are minor children or disabled children, you will have provisions in there that provide for guardianship and for conservatorship for the minor. You're nominating people into these positions. The guardian is essentially the person who takes control of the person of the minor. In layman's terms, what that means is if the testator dies and leaves behind a 12-year-old son, he will nominate somebody to be the guardian of his son, and the guardian will decide where's the kid going to school, where's he going to live, and who's going to make health and what sort of healthcare decisions are going to be made on his behalf. The conservator is going to be the person who decides how are we going to spend the money that's left for the 12-year-old son. So often they can be the same person, but they don't have to be. So we delineate in the will there's a guardian appointed and a conservator appointed, which may or may not be the same person. I think, Brandon, one of the things you've seen in our work together is families, especially married couples, this is a big issue for them about who's going to take care of our kids after we're gone. The spouses both say, we'll have to think about that, because they're both thinking, I like my brother-in-law, but I'd much prefer my sister. And the husband's thinking, I'd like my sister-in-law, but I'd much prefer my brother. And so that's where one of the points, most often the points of contention or where it takes some thought is who's going to step into these roles. The other thing to think about in a will, the will will say, I leave my property in this manner. Again, my example, house to brother, cash to sister, everything else to my nephew. Even with a document that says that, you have the opportunity to create a memorandum that says, even though I said everything else to my nephew, I want my niece to get my watch, or I want my cousin to get the grandfather clock, or other types of tangible personal property, which, as you know from our work together, tangible personal property is tables and chairs and forks and knives. It's the example of anything that's not cash and anything that's not real estate, generally speaking, is tangible personal property.
The biggest thing would be the jewelry, right?
Correct. That's correct. And that and collectibles. So that's what people will do is, rather than go through the house and putting Post-it notes on the back of everything, or rather than creating a 40-page listing in the will of everything they want to go to everyone, they will create a separate memorandum that allows you to say, I leave my watch to my cousin, or I leave my grandfather clock to this person. And that list can be as long as you want, and you can change that list without having to go back to the lawyer's office and having it notarized and witnessed like we talked about for authenticating a will. The only caveat to that is, as we talked before, is that when you're saying I want something to go to someone, you have to be specific. Not my favorite watch to my favorite nephew, because nobody's going to know what that means after you're gone. The remainder of the language we talk about next is distribute the remainder of the property to the beneficiary. So typically the will says I leave my tangible personal property to these family members, and then I leave the rest of my property to some other group, and often it's the same family members, or this is where it would say I leave it to my trust. And as we get into the trust discussion, even if you have a trust, you will have a will. And the will say that upon my death, if I have a trust, I leave my property to my trust. You also name the personal representative in the will to carry out the wishes. So essentially the testator picks somebody who's responsible for making sure that the brother gets the house and the sister gets the cash and the nephew gets everything else. Somebody's got to sign the deed for the estate. Somebody's got to go to the bank with the power to empty the bank account and transfer the funds to the sister. That's the personal representative. So moving on to the next. The other standard document for an adult with capacity in Massachusetts is a Massachusetts healthcare proxy. This, as you would expect, is the document that names somebody to make healthcare decisions for you. And it's only effective if you can't communicate your own wishes for healthcare. So what do I mean by that? There's two things to note about the healthcare proxy. One is, unlike the will that's only effective at death, this is effective immediately, meaning that the day you sign it, it's valid. It's not, doesn't have to wait to your death, but it is limited by, it's only effective if you can't communicate your own wishes. So my wife is my healthcare agent. If I go to the doctor and he gives me some options for a health issue for treatment, I make those decisions as long as I can make those, as long as I can tell the doctor what my decisions are, even if my wife is my healthcare agent. She doesn't have the right to trump my decisions. It's only if I'm not able to communicate my own wishes. And we'll contrast that with the power of attorney in a moment. But this is a standard document for healthcare that all adults in Massachusetts should have.
Now, one of the questions that I get a lot is, okay, I think I filled one of those healthcare proxies out at the doctor's or at the hospital or something.
Right.
How would you compare and contrast, a healthcare proxy you would put together versus what their doctor's office would make them put together?
I think what you find, or what we found anecdotally, is that, well, we always put a healthcare proxy together with every estate plan we do, and we follow there's a statute for this that we follow pretty closely in format and template. But and I think of it as more as the emergency healthcare proxy, because there's been an accident and the person isn't in a condition to sign another healthcare proxy. So, but if it's planned surgery or planned healthcare, the medical world will look at the healthcare proxy that you've signed with Guarino's law firm and go in with it, and you go in and say, here's my healthcare proxy. They'll say, that's great, but we have our own form that we'd like you to sign. Mm-hmm. And they should be for the same purpose, and ideally they follow the same statutory language, but everyone drafts things a little bit differently, and I would expect that their language is a little more self-serving for the doctors. To help the doctor do their job more efficiently than maybe they would prefer in our proxy.
Another question I get is the healthcare proxy where we talk about end-of-life decisions. So I'm in a vegetative state, and I don't want to, I don't want extraordinary things being done to keep me alive. Is it in the healthcare proxy or somewhere else?
It is in the healthcare proxy, sort of, because in Massachusetts they don't recognize some of the other documents that other states have for end-of-life decisions.
Some of those other states that I mentioned earlier, do any of those have?
You'll have to talk to a Texas lawyer, but I assume that other states do have,
like a true attorney,
do have more robust documents for that. In Massachusetts, what generally happens is I name my wife to be my healthcare agent, and with that power, she'll make those decisions for me. She'll rely on what I've communicated to her during my lifetime as these are my wishes. But what I'm telling her are my wishes, not musts. So by giving her the healthcare agency, I'm essentially giving that decision to her.
Next.
Yes, please. So moving on to the durable power of attorney, this is the other lifetime document that is, if I give my wife my power of attorney, she has the ability to help me manage my own assets and do anything for me that I can do for myself regarding my financial assets. So that would be cash, that would also, I should say, in terms of property, it's not just financial assets. It also includes real estate. She could sign the deed for our house and things like that. So typically, we name a power of attorney and we make that effective. My preference is to make it effective immediately. So you contrast that with the healthcare proxy. That's only effective if I'm incapable of communicating my own decisions. The power of attorney that gives my wife the ability to manage my property is effective immediately. It also, one of the things that we put into the power of attorney is that question of whether we give that person the power to make gifts. So typically, I would give my spouse, and my power of attorney, my wife has the ability to take my property and give it to herself. There are creditor protection reasons or tax reasons or Medicaid planning reasons that it's useful for spouses to be able to transfer property back and forth. Typically, but again, not always, if we have the brother as the power of attorney or one of the kids as power of attorney, we don't give them the gifting power. So that's less obvious and less likely that it's to the parent's benefit for the son to be able to take their assets and put them in their own name, and less so even for the brother. Mm-hmm. So that's usually the distinction in the power of attorney, but my preference is spouse has the ability to make gifts and the spouse has that capacity effective immediately. There is a theory that, or there is a alternate option in a power of attorney that it's only effective upon incapacity. And that means that my wife has my power of attorney, and if she can prove that I don't have the capacity to act for myself, she can step in. I think the challenge with that, and this is something that Brendan and I have talked about a number of times, conceptually, if I'm disabled and incapacitated, she gets proof of that today and comes to Waymark and says, here, David's incapacitated, here's the doctor's note, I want to do this, this, and this with his investments. And then 3 weeks from now, she comes back, Brendan should be asking, well, is he still incapacitated? You have to prove that again. And if we have a lot of things going on, she has to prove it every time she deals with it. So I think that's for my preference is to have it effective immediately. Mm-hmm. And
so that makes it an extremely powerful document, because if someone wanted to, let's say that you gave the power of attorney to a child, and let's say that child was in kind of financial straits, they could take advantage. They could actually start taking money out of the account. And me, as a financial professional, if they have a document that says that effective immediately, they can make decisions on David's behalf in this example, I have to listen to them. And a bank has to listen to them. A financial institution, Fidelity, has to listen to them. So it's an extremely powerful document. But it's definitely one that I think, again, sometimes when I talk to people, they say, well, I have a will, I'm all set. And this is where I say, well, do you have a durable power of attorney? And they say, oh, not really. Or I think I have that, but I think we did it like 10 years ago. And, talk a little bit about that, Dave, because the logistics of a power of attorney sometimes don't match up with the law.
I think that's right. I think that the will is conceivably something that you do once and you never touch it again until death. And this is something you can create when you're 20, and conceptually, if circumstances in your life never changed, it will be effective at death at 90 years old. But a power of attorney, though it says durable power of attorney and it's supposed to last for the rest of your lifetime, you are unlikely to get that power of attorney honored by any financial institution if you signed it at 20 and now you're 35 and your wife or your cousin or whoever's named in there goes into the bank and says, I've got David's power of attorney from 23 years ago. They're not going to accept that. And rather than get into a legal battle with them about the effectiveness of a durable power of attorney, the better, more prudent plan is to just simply update that power of attorney every 2 years. That precludes the winning for losing, fighting with the financial institution to say that my 20-year-old power of attorney is technically good, but it took me $10,000 in legal fees to prove that, when I could have just updated that power of attorney 3 years ago in half an hour's work.
Yeah, and I think that's a really important point. We here at Waymark, we're always telling clients every 5 years you should have your estate planning documents looked at. But there are some financial institutions that will do one of two things: either not take a durable power of attorney that you draft with an attorney and say you have to fill out our Bank of America power of attorney. Picking on Bank of America because I think they're one of the culprits there. The other thing that sometimes these institutions say is, okay, well, let me take a look at it. Oh, I'm sorry, we can't use this because it's dated more than 2 years in the past. And so you need a refreshed one that just simply says, even if it says the exact same thing, it just needs to be dated 2019, not 2017 or something. So the durable power of attorney, again, very powerful document. And the reason why banks and everyone are so finicky about it is because you're pretty much giving the power to act financially to someone else. So effective immediately.
I think that's the really good summary of the documents that every adult who is of capacity in Massachusetts should have: the will, the power of attorney, and the healthcare proxy. And no matter what your financial circumstance or marital status or health or any of those things that would go into the trust decisions that we'll talk about momentarily, you should have those documents. And so now we get into the optional document, which is the trust.
Yeah, let me pause you on that because, you said everyone should have them. So I guess some younger clients who say, well, I'm not married yet, I don't have any kids, why do I need a will, power of attorney, healthcare proxy? What would you say to them?
A couple different things. One is to control where your property goes, and if you don't have a will, then the state rules will control who gets whatever you leave behind. And for some kids, they're going to say, well, that's fine, it's going to go to my parents, that's what I want anyhow. But if you want some choice over that, that's where the will comes in. The other part of that is, again, assuming no kids, and so we're not worried about guardians and conservators for their kids, which is a compelling reason for a power of attorney, a will. You also make it easier for property to end up where you want it to end up. If you die without a will, then you have to go through an intestacy process, which is still a probate court proceeding. Again, it's not a lifelong commitment to the probate court, but it's something that you could avoid by having a simple will. I think the power of attorney and the healthcare proxy are even more compelling for someone who's 19 years old and says, I don't have anything.
Yeah. What's interesting about that is that I think a lot of people don't realize what they do have. So for instance, they may pass away at age 23. I think, and we actually know someone that did. I won't get into the situation, but he had, I believe, a $50,000 life insurance policy through work and didn't designate it as a beneficiary. So in that case, there was a $50,000 estate that had to go through probate, and to Dave's point, it goes through the intestate process because that asset didn't know where to go. So the state makes that decision if you haven't designated anything using the will.
Right. Yeah, I think those are the compelling reasons for the will. I think that just to finish the answer for the proxy and the power of attorney, even an 18-year-old can become incapacitated, and it's important for someone to be able to make those legal decisions. If the child is 19 years old or the young adult is 19 years old and he becomes incapacitated and someone has to make medical decisions for him and there's no healthcare proxy, the parents can't go in and say, well, we're his parents, we should make these decisions. But hospital or other medical facility is going to say, well, we need you to have legal authority to do that. And if you don't have healthcare proxy to do that, you have to go get guardianship or seek approval elsewhere. And that's all of which could have been avoided by a simple healthcare proxy. And same for property management with a power of attorney. These documents preclude having to go get court approval to do the same thing.
All right, Dave, we're at the half-hour mark right now. I don't see any questions.
Okay.
No questions yet. So we're going to get into the trust, and as I mentioned, we're going to try to keep this to 45 minutes.
Okay.
This is where I know Dave could go on for hours on trusts, because trusts are, we just got through the basic estate plans and it took us a half hour. But let's see if we can wrap up the trust in a 15-minute period.
Sure. So starting with a trust, just to set out the basic ground rules of what is a trust, and trust is essentially a legal arrangement where somebody transfers property to somebody else to hold for the benefit of a third party. So a good example is I give the babysitter $20 to hold for the kids and buy them dinner. Technically, I'm the grantor, or you'll hear the term trustor, settlor, donor, creator, all means the same thing. I'm the person who sets up a trust. I give the $20 to the babysitter. She is now the trustee to hold for my kids, to buy them dinner or buy them an ice cream or something. Those are the instructions I've given her, the trust restrictions for the kids who are the beneficiaries. So that's an extremely simplified example, but it's generally, a trust is a 20 or 30-page legal document that says somebody transfers property to somebody else to hold for the benefit of a third party. And typically those trusts can either be revocable or irrevocable. A revocable trust is something that the grantor can change. So they can change the terms of it. They can say, hold it for me for my lifetime, and after I'm gone, leave it to my brother, and then 3 months later say, after I'm gone, make half to my brother and half to my sister, and then 3 months after that, make it all to my sister. So the whole thing can be changed as long as the grantor is competent. An irrevocable trust, which is used sometimes for tax planning or used sometimes for Medicaid or other purposes, is something that the grantor can't change. So in my example, they create a trust that says, hold it for me for a lifetime, and at my death, it goes to my brother. 3 months later, I change my mind and I want half of it to go to my sister. I want all of it to go to my sister. I can't change that document. So there's usually a tax reason or a control reason that it's in my interest to create a trust that's irrevocable that I can't change. But there are obvious consequences to that, which means that it's essentially permanent, or I should think of it as permanent when I create it. That's the law still allows some flexibility, but the general concept should be that if the trust is irrevocable, you shouldn't plan on changing it when you change your mind.
When Dave says Medicaid, and many of you already know this, but just to be clear, irrevocable. So I get a lot of questions about nursing home protection, and they say, well, I have a trust, I'm all set. And I say, okay, is it revocable or is it irrevocable? And if it's revocable, no protection. If it's irrevocable, could be protection, but it has to be written properly in order for that to actually work for Medicaid purposes. And when I say Medicaid, again, nursing home protection. So I'm just throwing that in there.
Okay.
Because I know that's a pretty common question I get from a lot of people.
And the other thing, just for nomenclature or for trust setting up, often the trust that we set up the grantor, the creator, will be the trustee and the first beneficiary. So typical estate plan, I'll create a trust for myself that it's held for my benefit. I name myself as the trustee and I name myself as the beneficiary. So for all three purposes, I'm the grantor, I'm the trustee, I'm the beneficiary. That will change over the course of lifetime, that after I'm gone, or someone else will step in as trustee, and typically somebody else after that will step in as beneficiary. But that's the basic for the estate plan, for trust planning. Move on. So again, the reasons to use a trust, as we just broadly outlined, there's asset management and probate issues, like we talked about with the will, and we'll get into in a moment, tax planning, and beneficiary concerns. And I think that we'll go through the asset management and probate pretty quickly, because we've talked about probate related to the will, but moving ahead to the probate issue, probate planning.
Give me 1 sec, Dave. Looks like we might have a sound issue again. I'm saying this is a sound. So, just okay, we're going to try this again.
Okay.
My understanding is that the audio cut out, so I apologize for that.
Okay. So let's just move ahead to, we're talking about the reasons to create a trust, and one of them would be asset management and probate. For asset management, I think of this as most stereotypically a person who is in failing health and is concerned about their ability to manage their own affairs. They will put property in a trust that will allow somebody else to help them to manage their property. And that's for someone with diminished capacity, or it's also commonly used for somebody who wants a professional advisor managing the trust.
For the audio difficulties again. Testing, testing. Okay, I'm going to put a poll here. Brandon's giving me a notification that that you can't hear us, but I do see that there is audio that seems to be popping up. So, okay. So I see one person who says that they actually can hear us just fine. So I'm going to put a poll here and make sure that people can hear us. Apologize for this. We're going to launch this poll. Okay, so let's see if everyone can hear us. Brandon says he can't hear us. So we got, so far, 4 people can hear us, 1 person can't. I don't know if that's Brandon.
Maybe he spent it on you.
That's what I'm thinking. All right, so we're just going to keep going and assume that everyone can hear us okay. All right, sorry about that. I apologize for all the audio difficulties we've been having with this one. All right, continue.
So, again, we talked about the reasons for creating a trust, one of which is asset management and probate avoidance. Asset management is because the person creating the trust is concerned about their ability to continue to manage their affairs, and it would be useful to have somebody else step in that role while still retaining control as the grantor of the trust and still retaining the benefit of the property as the beneficiary. The other reason for creating a trust is probate avoidance. All the things that we talked about that would create a little bit of trouble at creating when you have just a will, that you have to go through the probate process. You can avoid that by putting property in a trust. And the trust would be something that's designed to say that it's the same disposition. My house goes to my brother, my cash goes to my sister, and everything else goes to my nephew. I can put that in a trust rather than in the will, and then I don't have to have my estate probated. Alternatives to that include designated beneficiaries and joint accounts. So I could put my brother on the deed to my house, and I could put my sister on my bank account, things like that. It's challenging to do that with everything you have, but those are probate alternatives so that we don't have to go through the probate process to get the property where I want it to go after I'm gone. Move on to the next. Taxes are a very common reason in Massachusetts for creating a trust. Obviously, not so common in the states that we talked about that where you have attendees who don't have state estate tax to worry about, which is just about everywhere outside of Massachusetts. Massachusetts, there's $1 million exemption. So if a person dies with $1 million, they don't owe any estate tax. If they die with anything more than that, they do owe some estate tax. And in Massachusetts, what does it mean to have $1 million? As you talked about, that's more than just having $1 million in a bank account. That's including the equity in the home. That's including death benefit from life insurance, including 401ks and retirement plans and jointly held assets. All the things that you don't think about easy access to, especially like something like life insurance. But it's something that counts when they're looking at whether you had $1 million for estate tax purposes. So commonly for married couples in Massachusetts, we will create trusts that are reciprocal so that my wife is the beneficiary of my trust, I'm the beneficiary of her trust, and by using reciprocal trust in a way that has tax planning language in that, we can double the amount that we pass to the kids free of estate tax from $1 million to $2 million. If we don't have the trust, if we just have simple wills, that I have a will that says I leave everything to her, and she has a will that says she leaves everything to me, at the death of the survivor of us, we will pay probably about $100,000 more of Massachusetts estate tax than we would if we use separate trusts. And so that's a compelling reason for married couples to use trust in Massachusetts for estate tax planning.
So a couple points on that that I hear a lot from clients is, how about tax-free assets? Do they factor into this estate tax calculation? So if I have a $200,000 Roth IRA that's tax-free, does that factor into the estate tax calculation?
Yeah, absolutely. And it's different tax that it's tax-free from. So tax-free assets generally mean income tax-free. So estate tax is measured is essentially just what did you own in whatever form it was and what is it valued at, and then we're going to put a tax on that based on the valuation of it, regardless of whether it's all in life insurance that you'll never spend or I've got a $3 million 401k. There'll be income tax and estate tax or something like that. Yeah. But general concept, yes.
Yeah. Two other places where I think people underestimate what kind of estate tax exposure they have is businesses. If they have an ownership in a business, for any ownership purpose, ultimately if someone passed away, they're going to have an appraisal done on their share of the business and potentially have to pay estate tax based on that value of the business. The other thing is the life insurance. Again, I get a lot of younger couples, they say, oh, no, I don't have to worry about death tax. That's only for rich people. Then I say, well, what's your life insurance coverage? Well, I got $1 million. My wife has $1 million. Well, there you go. There's your $2 million that puts you in that $100,000 tax situation that Dave was just alluding to a moment ago. So you definitely have to be really careful with this. When we say that estate tax that the estate tax is all-encompassing. It really is. Everything that you have your name on could potentially be part of your estate, and therefore a tax be levied on it.
Yeah, I agree. I think the last portion of planning for a trust, and we'll go to the next slide. This is the other and probably the most common driving reason for leaving a trust. And that's because we have some concerns about what we leave to people. It's not so much the tax planning, it's not the worry about the control that the grantor would have, it's not worried about capacity. It's generally much more common that the reason we have a trust is because there's a reason we don't want to leave something outright to the people that we want to leave our property to. So you'll see the three lists here of capability and responsibility and tax concerns. Essentially, what we're looking at here is if you've got minor children, you don't want to leave something to them outright, so you use a trust for that. Instead of leaving something to my 12-year-old son, I leave it in trust for him, and then he'll get the benefit of it, but without being in charge of it. And same with my 20-year-old son. I'll leave it in trust for him. I won't leave it outright to him. I'll leave a trustee in charge of it, but he'll be the beneficiary of it. When a common example or one of the things that becomes frequent in our practice is a supplemental needs trust because one of the children has a disability of some sort. That's a reason to create a trust. There's also the in-law problem where parents have created or accumulated some wealth and they want to leave property to their kids, and they will say, well, I love my daughter, but her husband I have some questions about, or vice versa.
I heard that a couple times.
Yes, and so that's where you would create a trust that says, I don't leave it outright to my daughter because that's tantamount to leaving it to my son-in-law. I instead leave it in trust for my daughter, and that takes care of, I'm worried about an unstable marriage or all the things that go along with family planning like that has concerns about the ability of other people to get at your kid's inheritance. And the higher the level of wealth, the more we're concerned about tax issues. So for a wealthy client who's leaving a significant amount to their kids, and their kids are self-sufficient in their career and are paying their own bills, they look at it and they think, well, my kids, I'm going to leave them a significant amount, but they're not likely to spend all of that during their lifetime. Leaving it in trust for them so that they can leave whatever they don't spend to their kids free of being taxed in their estates makes some sense for them also. So I think that those are the main concerns. We're worried about the capability of the beneficiary or the responsibility of the beneficiary, and that's the one with the luxurious spending habits, for example. And then the tax and creditor concerns of why kids have creditors chasing them because he's been in a car accident or she's got a former spouse. I don't want to leave it to her directly or to him directly because that's giving half of it or some portion of it to her creditors, that I could avoid that by leaving it in trust for them. And for the wealthier families, we'll use tax planning in trust like that. Yeah. So I felt like I zipped through that, but that's, I think, the end of our broad discussion of why to use trust and why to use where they would integrate into the plan. Just to kind of sum up the broader points that we made. Every adult, I think, needs to have a will, a durable power of attorney, and a Massachusetts healthcare proxy, regardless of their financial situation, regardless of their circumstance. Beyond that, you get optional concerns about whether a trust is necessary, and those will be primarily just driven by concerns about beneficiaries. So who am I leaving my property to? Or do I have estate tax concerns in Massachusetts because we've accumulated more than $1 million? Or am I worried about Medicare or Medicaid or Mass Health in Massachusetts for other reasons from failing health from the person who's creating the documents?
Okay. All right. So with that said, as I said, we're trying to keep this under an hour, but we do have about 10 minutes for questions, if anyone has any questions. I know we have about a dozen people online right now, so, and like Dave said, you know, we kind of zipped through the trust part, and the trust part is probably a lot more complex than what we talked about for the first half hour. But with that said, you know, I think the trust piece is very individualized. But with that said, we have 10 minutes with Dave. Any questions that anyone has? You know, again, at the bottom of the screen, there is a Q&A button. all you need to do is just click on that and type in your question, and we'll try to answer them. So give about a minute on that to compile questions, and if we don't get any new questions, then we'll let you get back to your lunch. Trying to think if there's anything that should touch upon while we're compiling the questions.
Well, I think one of the things that you talked about earlier, that's just worth reiterating, is the beneficiary designations and the part of the estate planning, the most basic estate planning, even for people that don't have trust. One of the things that Waymark does, and you should always be careful about, is looking carefully at who are the beneficiaries of your life insurance at work, for example. Many people don't even realize, don't think about that twice when they have a policy at work, or they have a bank account that's set up that's in their name and they're in charge of it. They don't realize that 5 years ago they set it up that has a beneficiary designation or something like that. Those things are always part of the estate plan and always part of the concern of you create this document that says it does this and I leave it here and this goes there, and then you find out beneficiary designations are inconsistent with your current wishes. So you've had a policy at work for 12 years. That 12 years ago you said, I give to my brother. Now 12 years later, that's a terrible idea, but nobody thought about it. You just figured the insurance is just going to go to my family, and my estate plan will take care of that. That's an important thing that should always be emphasized. You need to look at the beneficiary designation part of the estate planning.
All right. One of the things in switching over to the special needs planning, where we see the beneficiaries really being incorrect, frankly, is that let's say that your son has special needs. If you just simply say, I give half to my daughter and half to my son who has special needs, well, that could potentially cause them to lose benefits. And that's where you get into special needs planning, special needs trusts, things like that. So, the beneficiary, we try to look at those at least on an annual basis with clients because it is very, very important. And when someone a client does unfortunately pass away, we do find, sometimes that the beneficiaries are stale and things are going in the wrong place, and there's nothing you can do after death. Well, there are, but it becomes much more costly and complicated to kind of amend things if the beneficiaries are off. So I see that we do have a question. Let's see what this is. Okay, so I guess we triggered something. So special needs trust, special needs planning. So Dave, talk a little bit about that. We talked about revocable trusts, irrevocable trusts. Are special needs trust a third type of trust, or does it fall into one of those categories? Or
it can fall into either. Essentially, a special needs trust is something that's set up typically by the parents to say that I'm going to leave some portion of my estate to a child with a disability or a relative with a disability, that says these funds will be available for the benefit of the person with a disability without being considered a resource of theirs. So if they're on a program that's based on their resources, such as certain types of mass health or things like that, the assets that are left through the special needs trust don't disqualify the beneficiary.
And it could be significant. A lot of times what we do with special needs planning is we'll have a life insurance policy and the beneficiary is the special needs trust. So there could be $500, $1 million in that. And if that money ended up in the ownership of that child, they're considered to now have $500,000 to $1 million of assets, and that could potentially eliminate them from getting government benefits.
Right, and that's the way that trust typically works. Is the beneficiary has no right to say, I want anything from this trust, to demand a distribution, and because they can't demand the distribution, then that qualifies as a trust that is not an asset of theirs. And so this is common planning for special needs families. It's to create this third-party special needs trust and integrate it into the rest of the plan.
Yeah, and one of the things that I think there's a little bit of, so just logistically, sometimes the way that this works, let's use that example. We have a daughter and a son who has special needs. You create that trust for that child, for the son, but just know that it doesn't necessarily need to be funded during life. If you pass away, you can make the beneficiary that trust, and that holds the assets for that child. so that it doesn't end up in their hands and potentially disqualify them from getting benefits.
Right. That's the most common planning scenario. Parents hold on to the assets for as long as either of them is alive. Then after they're gone, when just like any other family, that's when the parents decide they have a decision about what gets divided among the children. The share that goes in your example to the son would instead go to his special needs trust.
Right. Good. Any other questions? That was the only question that we've gotten so far. Give you one more minute, and then we'll wrap up and call it a day. All right. Looks like we're pretty quiet. If something does pop up while I do the closing remarks, Dave, anything to close with, or pretty much summarize it in the last?
I think that what I'm hoping that people get out of this is a useful reality check for them before they meet with their lawyer, meet with their financial advisor. What should I be expecting when I go in there for advice about, do I need an estate plan, rather than being concerned about, because there's always a concern, I think, that the lawyers are going to sell me 7 different trusts that I don't need. And how can you reasonably refute their analysis about whether you need a trust or not? That's always the biggest concern. And I think that if you go in knowing that they should recommend power of attorney, healthcare proxy, and will, and then the options for a trust was based on these different concerns, I think that gives you a little more confidence that what you're being sold is appropriate for you.
Right. Okay. Well, thank you everyone for joining. Hopefully this was helpful for everyone. Feel free to reach out to us if you do have any questions about anything that we talked about. I do apologize for some of the audio issues that we had during the conference or during the webinar. And keep your eyes open for our October webinar. We're going to be doing that on divorce planning. Hopefully it doesn't impact anyone personally, but I have spoken with, unfortunately, a couple folks that have children that may be considering as a divorce. So it's going to be on divorce planning, what to be thinking about in advance of a divorce. So thank you very much. Have a great day, everyone.